Governor Monday Okpebholo of Edo State has urged the Court of Appeal to overturn the decision of the governorship election petition that dismissed the responded preliminary objection to the admissibility of the BVAS machines during trial at the tribunal. Counsel to Okpebholo stated this during the cross-appeal by Governor Monday Okpebholo at the Court of Appeal. BTV News senior reporter Best Orator has details of the report.
Of the 4 appeals that are before the Court of Appeal in Abuja in regards to the Edo State governorship election, one is the cross-appeal by Governor Monday Okpebholo that is challenging the decision of the tribunal that dismissed their preliminary objections as it relates to the admissibility of the BVAS machines which were tendered from the bar. Counsel to the appellants, A.J. Owonikoko SN, said they have filed unnecessary processes and additional lists of authorities which they are relying on in support of their argument. He said where the respondents chose to cross-appeal separately without incorporating it with the trial of the appellant, the cross-appeal cannot travel alone to the appeal court or the Supreme Court. He said the respondents should have applied for consolidation with leave of court, so therefore the document is incomplete and they do not have the valid record. Owonikoko SN stated that grounds 1 to 4 of the cross-appeal are interlocutory appeal and are incompetent. He said the cross-appeal should be dismissed for lack of valid records to support it. Responding, Senator Monday Okpebholo through his counsel Okpebholo SN said they filed processes in the cross-appeal. He told the court to dismiss the preliminary objections by the PDP, saying that where there is an appeal and cross-appeal, both succeed to court as one appeal. He cited the case of Innocent Patrick Umar versus PDP and another case of Silva and said there is no issue of 14 or 21 days given for cross-appeal. He said the issue in grounds 5 cannot be academic as claimed by the appellants. Okpebholo explained that the appellants at the lower court tendered what they called BVAS reports and what they claimed to be BVAS extracts but was actually BVAS screenshots, and therefore argued that the Supreme Court heard in Oyetola versus INEC case that the screenshots is not enough to prove a case of non-compliance and that what was needed is the BVAS machines. He said in the case of Aso Ighodalo and PDP, the BVAS machines were not tendered through any witness but tendered through the bar, and that the BVAS, being an original document, cannot be tendered from the bar. He said the cross-appeal is not academic at all because allegation of overvoting cannot be proved in the absence of BVAS machines. He told the Court of Appeal that the machines were tendered after 15 witnesses had testified for the appellant and the machines were neither open nor demonstrated, and respectfully urged the court to dismiss the objection, allow the cross-appeal and the main appeal be dismissed. Also, the appeal of the Action Alliance and Accord Party were also entertained. The appellants in the 2 appeal are praying the court to set aside the judgment of the Governorship Election Petitions Tribunal. The respondents, on the other hand, said the court should dismiss both appeals for lacking in merit. After listening to the submissions, the court thereafter reserved judgment. Best Orator reporting for BTV News.